Thank you so much for having me. It really is a thrill to be here today. I've been coming to this symposium since I think about 2005 when I was a graduate student at the University of Maryland, and I'm very grateful to the Abraham Lincoln Institute for inviting me. I'm also grateful to the Institute for awarding me last year's Hay Nicolay Dissertation-Prize in conjunction with the Abraham Lincoln Association. My talk is derived from my forthcoming book, which is entitled Abraham Lincoln and Treason in the Civil War, The Trials of John Merryman, and it'll be published next November by LSU Press. The book focuses on the famous 1861 Habeas Corpus decision, Exparte Milligan. Now, Exparte Milligan was a landmark court decision in which Chief Justice Roger B. Taney ruled that President Lincoln could not detain citizens without charges. And what I'd like to do today is retell the story of Exparte Milligan, but expand on it with some facts and stories that you may not be familiar with. And I'm pleased to say that there are several descendants of John Merryman in the audience, a great-great-granddaughter, Susie Merryman, and another descendant who I haven't met yet named John Merryman, a namesake of the subject of today's talk. And I hope that nothing I say comes as too much of a surprise to them. Let's see. I have a computer up here, so tight space. When Abraham Lincoln looked out of his White House window in April 1861, he faced an enormously difficult situation. The Deep South and several Upper South states had already seceded. Lincoln now had to keep the border slave states in the Union. Indeed, Lincoln said that losing the border states would be equivalent to losing the whole game. As part of his strategy for keeping the border slave state of Maryland in the Union, Lincoln authorized his General-in-Chief, Winfield Scott, to suspend the writ of habeas corpus along the military line between Philadelphia and Washington, D.C. Well, what did this mean? Put simply, it meant that Union military authorities could arrest and detain civilians and hold them indefinitely without charges. A writ of habeas corpus is an order that a judge can issue when someone is being detained without cause. The writ requires the prisoner to be brought before the court so that the judge can determine whether the detention is lawful. If the judge thinks the detention is unlawful, then he orders the prisoner to be released. If he thinks the detention is lawful, then he orders the prisoner to be sent back to prison and charged with a crime. Now, as we all know, Lincoln's decision to suspend the writ during the Civil War was very controversial. The Constitution permits the writ to be suspended when, in cases of rebellion or invasion, the public safety may require it. Certainly, Lincoln faced an instance of rebellion. The controversy arose because the suspension clause is in Article 1 of the Constitution. And for the lawyers in the room, we know that Article 1 is the part of the Constitution that has to do with Congress. And so from 1787 until 1861, most legal observers assumed that that meant that only Congress could suspend the writ. Lincoln claimed otherwise. And I won't get into the issue of presidential suspension of habeas corpus during my talk, but I'm happy to address it during the Q&A. Now, when scholars look at the habeas corpus issue during the Civil War, they tend to focus on the arrests at 2 a.m., the incarcerations in military prisons, the military commission trials that followed many of these arrests, and the habeas corpus proceedings in which prisoners sought to win their freedom. The most famous cases involve a Baltimore County farmer named John Merryman, an Ohio congressman named Clement Vallandigham, and an Indiana lawyer named Lambden Milligan. But there were many other similar cases that arose during the Civil War. Now, historians usually describe these conflicts, or these cases, as a conflict between the executive and judicial branches of the federal government. And they were. Ex parte Merryman, for example, is famous today because of the enormous collision that John Merryman's arrest caused between Abraham Lincoln and Chief Justice Taney. My contention today is that these famous habeas corpus cases are very significant, but that their importance does not rest alone in the issue of executive power in wartime. These cases also tell us a tremendous amount about the practical difficulties facing the military and the precautions that Lincoln had to take to protect his officers in the field. When we think about the military arrest of civilians, we naturally think about the effects that these arrests had on the civilians themselves. We don't tend to think about the effects that these arrests had on the military commanders who did the arresting. And today I'm going to use John Merryman's case as a lens through which to examine what I am calling Lincoln's other habeas corpus problem. So if I can take us back to Maryland in April 1861, and to do that, I'm going to use a Google map from 2011. I want to use this map to illustrate the landscape in which Lincoln was suspending the writ of habeas corpus between Philadelphia and Washington, D.C. And interestingly, for our purposes, the lines of transportation were very similar from 1861 and 2011. The railroads that went between Pennsylvania and Washington tend to follow our interstate highways. And so if you can see I-95, maybe some of you drove down I-95 and were stuck in traffic to get here today, a railroad line went from Philadelphia to Wilmington to Baltimore. Another railroad went from Harrisburg down to Baltimore along today's I-83. And the B&O Railroad came in from the west along roughly Route 70. And all of the trains, when they got to Baltimore, arrived at different stations. And on this map, this is the Baltimore Harbor. On the east side of the harbor, you can see President Street Station. And on the west side of the harbor, you can see Camden Station. If any of you are Orioles fans, I'm sure you're very familiar with that site. Now, the city of Baltimore erupted in violence on April 19, 1861. At 10 that morning, the 6th Massachusetts Volunteers and 1,000 unarmed Pennsylvania soldiers arrived at Baltimore's President Street Station on the east side of the harbor. As a professor, I'm very proud of my ability that's about the extent of my abilities with PowerPoint. And I have to say, my wife taught me how to do that. The way the train system worked in Baltimore in those days was that the trains coming down to President Street Station from Philadelphia had to be detached from their locomotives and drawn by teams of horses about 1.5 miles through Baltimore, and then they were reconnected at Camden Station on the other side of the harbor. And from that point, they would then travel southward to Washington, D.C. The first 6 cars, carrying about 400 Massachusetts soldiers, safely made it to Camden Station. But a mob rose up, laying anchors, sand, and other debris along the tracks, so that the remaining soldiers couldn't make it across the city in their railroad cars. The troops evacuated the cars and marched to Camden Station, fighting the rowdies as they went. Eventually, the Massachusetts soldiers made it to Camden Station. The mob then turned its wrath on the Pennsylvania boys back at President Street. One witness recalled the horrors that he saw. Quote, "I saw a soldier in the gutter and 2 men kicking him almost to death. The police officers were holding him down while the men were kicking him. In all, at least 4 soldiers and 12 civilians died in the melee." Now that night, Baltimore Mayor George William Brown, Maryland Governor Thomas Hicks, and Baltimore Police Marshal George Kane all met at the mayor's house to determine how to stop more Union soldiers from passing through their city. The solution they devised was to burn all of the railroad bridges around Baltimore. It made some sense. If the railroads couldn't pass through Baltimore, then Union soldiers couldn't either, and there wouldn't be any further mob violence. So I'll show you a 19th century map this time. So on the night of April 19th and early morning hours of April 20th, members of the Maryland Militia and Baltimore police went out and burned railroad bridges and cut telegraph wires all around the city. Northern troops continued to come down from Pennsylvania, but now their trains were forced to stop north of Baltimore when they got to the burned bridges. Several regiments of Pennsylvania soldiers were stuck in Cockeysville, Maryland, which is about 14 miles north of Baltimore. According to one account, a local resident named John Merryman, quote, offered to render the troops any service required, and if necessary, would slaughter his cattle to supply them with food. Now, I had to include this image of John Merryman's cow for a very important reason. When I bought this on eBay, my wife looked at me and said, "Why on earth do you need a picture of John Merryman's cow?" And now I think hopefully I've justified, or bull I should say, hopefully I've justified my purchase on eBay. This is a better one that also came up on eBay, but it was too expensive. And this shows Merryman's herd and his home hayfields in the background. Now, with the troops in Cockeysville camped outside of Merryman's home, the mayor of Baltimore rushed to the White House and told Lincoln that the presence of these troops in Cockeysville had his city, quote, wild with excitement, and he asked Lincoln to order the soldiers back to Pennsylvania. Trusting the wisdom and experience of his visitor, Lincoln agreed to order the soldiers at Cockeysville back to the Keystone State, and he also agreed to transport other Union soldiers around rather than through Baltimore in the future. So on April 21st, 1861, the president ordered the Pennsylvania soldiers at Cockeysville to return to the Keystone State. The soldiers packed up their belongings and prepared to go home. Meanwhile, a pro-secession militia commander at Baltimore ordered a local militia unit, the Baltimore County Horse Guards, to follow the soldiers back to Pennsylvania and to destroy the railroad bridges as they went. On April 23rd, under the leadership of First Lieutenant John Merryman, the Horse Guards galloped off to fulfill their orders as the Pennsylvania boys took the train back across the Mason-Dixon line. With sword drawn and brandishing a pistol, Lieutenant Merryman ordered his men to burn bridges and cut telegraph wires as the Pennsylvania troops retreated northward. Now, accounts of Merryman's behavior during this expedition conflict with the report that he was willing to sacrifice his cattle to feed the Pennsylvania soldiers. One witness claimed that Merryman shouted, quote, "God damn them, we'll stop them from coming down here and stealing our slaves." When on April 24th, a day later, someone confronted Merryman about what he had done, Merryman allegedly drew a revolver from his side, pointed it at the man, and said, "Damn you, what is it your business? We act under orders." And according to another witness, Merryman boasted that the Pennsylvania soldiers, quote, "were so badly scared that several of them fell dead when they heard that the Baltimoreans were coming." Now, this wasn't hyperbole. Merryman really did frighten the Pennsylvania volunteers. One soldier later recalled, quote, "During the night at Cockeysville, we had a number of alarms. The Baltimoreans came near our camp by the thousands, and all kinds of wild rumors were being circulated through camp. It was reported that 10,000 Baltimoreans were armed and equipped and marching against us. One man became very much frightened. He lay on the ground moaning, 'My God, we will all get killed.' I grabbed him and held him up and berated him for his cowardice. I, too, was badly frightened, but no one knew it but myself." Now, the Baltimore County Horse Guards patrolled the area throughout April 1861. They arrested several prisoners during this time, including a deserter from the Pennsylvania Regiment and a Baltimore County Unionist. The Unionist, named William Lovell, was a carpenter who had said at a local bar that the Union soldiers, should have been allowed to travel through Baltimore. Two of Merryman's subordinates went to the home where Lovell was staying at 11 p.m. on April 24th, and Lovell later testified that one of them drew a pistol and stated that if I made any resistance, he would shoot me. The two militia officers then bound Lovell's arms behind his back and forced him to walk 3 miles to John Merryman's home. Upon arriving, they found Merryman and a dozen other members of the Horse Guard sitting in their uniforms. Merryman approached Lovell and, quote, "told me that he heard I had been talking too much and that the county was very much excited, that they had their men all through the county and that they could not have any more such talk." The Horse Guards detained Lovell as a prisoner for the night at John Merryman's home. It was a richly ironic moment that can only be appreciated in hindsight. John Merryman, as a militia officer, oversaw the arrest and detention of a Maryland civilian without charges for speaking disloyally against the Southern cause. Well, now back to the familiar part of the story. By mid-May, the Union Army had rebuilt the railroad bridges and seized control of Baltimore. On May 25th at 2 a.m., federal soldiers went to John Merryman's home, pictured here, arrested him, and sent him to Fort McHenry in Baltimore Harbor. From prison, Merryman petitioned Chief Justice Roger B. Taney for a writ of habeas corpus. Taney immediately left his home in Washington, D.C., and traveled up I-95 to come to Baltimore. Taney issued the writ and had it delivered to Fort McHenry. But General George Cadwallader, the Union commander at the fort, refused to bring Merryman to the court. Instead, Cadwallader sent a subordinate officer to Taney's courtroom with a message that Lincoln had authorized him to suspend the writ of habeas corpus and to hold civilians without charges. As might be expected, Chief Justice Taney, a Southerner, a former slaveholder, a Confederate sympathizer, and the author of the infamous Dred Scott decision, was indignant. He issued an opinion castigating Lincoln for violating the Constitution and saying that Merryman ought to be released. Now, as we all know, Lincoln ignored the Chief Justice. He claimed the authority as president to interpret the Constitution for himself. And according to his interpretation, he possessed the power and obligation to suspend the privilege of the writ of habeas corpus and to detain citizens without charges when military necessity required it. The most thorough scholar of civil liberties during the Civil War, Mark Neely, has estimated that the Union military arrested about 14,000 civilians during the Civil War. John Merryman was but one of the first. Now, it would be easy to look at these situations and say the strong arm of the military overpowered American citizens and allowed military officers to act with impunity. And this is certainly true in some cases, but it isn't altogether true. And this is where I think the Merryman story gets interesting. So with the time I have remaining, what I'd like to do is make 2 points about Abraham Lincoln, the military, and the habeas corpus issue during the Civil War. The first point is that Union soldiers needed the federal government to protect them from allegedly disloyal characters like John Merryman. The second is that the lesson Abraham Lincoln learned from the Exparte Milligan case in 1861 stuck with him for the duration of the war. So I'll start with the first point. The frightened Pennsylvanians camped outside of John Merryman's farm in 1861 were not the only Union soldiers who were afraid of disloyal civilians on the home front. As hard as it may be for us to believe today, General Cadwallader was terrified of John Merryman and the consequences of having detained him at Fort McHenry. These are Cadwallader's own words. Quote, "I am myself vulnerable and liable to be harassed by Merryman and others in Baltimore. I will no doubt be arrested the next time I go to Maryland," and he added, "which I should regret at this time." Cadwallader's fears were not overstated. Indeed, a Philadelphia lawyer who was a friend of Cadwallader's said that the general, quote, "dreads the Merryman case." Well, why was a high-ranking Union officer afraid of a little-known farmer from Baltimore County? Cadwallader stated one reason explicitly, because he could be arrested by Maryland authorities for having perpetrated a potentially illegal arrest. But there was another more menacing reason, because John Merryman could sue General Cadwallader for damages for wrongful arrest, illegal search and seizure, or assault and battery. Several damages suits arose in various state courts in 1861, 62, and 63. These suits caused military officers to fear that they could be ruined, both financially or by criminal prosecution, for the actions that they took on behalf of the federal government. An officer of the 92nd Illinois Volunteers, for example, wrote to Senate Judiciary Chairman Lyman Trumbull, saying that suits against him, quote, "involve an amount sufficient to sweep away all my property if I am not protected." General Cadwallader was also deathly afraid of this sort of litigation. Privately, he wrote that the government, quote, "must in some way sustain federal officers in their official acts." In 1862, Union military officers began petitioning Lincoln and Republicans in Congress to protect them from this onslaught of litigation. Secretary of War Simon Cameron warned Lincoln that suits of this nature, quote, "are intended to divide and conquer your administration and thus bring Democrats into power." Indeed, Lincoln saw these suits as, quote, "a matter which deeply concerns the public welfare as well as the safety of the individual officers of the government." At a cabinet meeting in 1862, the issue of these sort of civil suits came up. And according to Attorney General Edward Bates, Lincoln, quote, "was a good deal stirred up and talked about arresting the attorneys." The cabinet decided that Congress should pass legislation protecting Union officers, but it took Congress about another year until they adopted such indemnifying legislation. Well, were Cadwallader's fears of John Merryman justified? Absolutely. On February 20th, 1863, John Merryman instituted proceedings against General Cadwallader in a Maryland state court, claiming $50,000 in damages for wrongful arrest. That's tantamount to about $900,000 today. The timing, however, could not have been better for Cadwallader. Less than 2 weeks later, on March 3rd, Congress enacted the Habeas Corpus Act of 1863. Now, this act is famous today for authorizing Lincoln to suspend the writ of habeas corpus. For our purposes, the act is important also because it offered protection to Union military authorities who arrested civilians in the course of carrying out their official duties. Section 5 of the act provided for the removal of suits of this nature from the state courts to the federal courts. It also stipulated that orders from the president could be used as a defense in any civil or criminal prosecution against a Union officer for any search, seizure, or arrest that they oversaw. Now, these provisions were very important. Now, military officers could produce orders from the president as a legal defense for the actions that they took. Moreover, by removing these suits from the state courts to the federal courts, the hope was, for Republicans in Congress, that federal judges would have the best interest of the nation in mind. If you think about it, state judges are elected by local voters. So a state judge in Baltimore might be sympathetic towards a local plaintiff like John Merryman. Federal judges, by contrast, are appointed by the president and not beholden to the people. And the hope was that they'd be more likely to uphold the Union war effort by ruling in favor of military officers. Now, these damages suits were tremendously important. Indeed, they were about more than just money. At the root was the issue of whether Congress and the president would protect the Union military as they carried out their duties in defense of the Union. William Schley, the lawyer who defended General Cadwallader, argued that these suits are, quote, of great importance, far beyond any question of pecuniary damage. If Congress did not protect military officers in the performance of their official duties, Schley continued, a public servant has a very thankless preferment. But General Cadwallader and others like him now had the protection that they needed, or so they thought. On the very day that Lincoln signed the Habeas Corpus Act into law, Cadwallader wrote to a friend, quote, "We may congratulate ourselves upon the passage of the indemnification law." Now, the problem for people like Cadwallader was the Habeas Corpus Act didn't negate the suits against them. It only gave them certain protections in court. And as a consequence, John Merryman continued to prosecute his suit against Cadwallader until April 1865. And he only finally dismissed the suit for very complicated, but I think fascinating reasons that I explain in the book. So there's a plug. But I'll give you a sneak preview since we're all here. Simon Cameron was Lincoln's first Secretary of War, and Simon Cameron also happened to be on the board of directors of the railroad whose bridges Merryman had burned in 1861. And Cameron's son also happened to be the president of that railroad. And Cameron was going around writing to Lincoln, trying to get him to rearrest some of the people in Baltimore who were suing him for damages. And at the same time, Cameron went to the railroad and induced them to start a suit against John Merryman for $200,000 in damages for having burned the railroad bridges 2 years earlier. And my argument in the book is that this countersuit was a way that Union military officers, Cadwallader and Cameron, saw themselves as protecting themselves against such litigation that Merryman and other disloyal civilians were prosecuting against the military. And it gives you a sense of the extent that military officers had to go to protect themselves. They would have to find a way to get a countersuit in order to occupy the attention of the civilian who was suing them. Now, some of the suits that came up during the Civil War lasted into the 1870s and 1880s, and the Habeas Corpus Act of 1863 really proved an inefficient means for protecting military officers. And I don't have time to go into the details here, but in 1866, Congress amended the act to give it teeth so that it really would offer more protection to Union officers in the post-war period. Now, the second point I'd like to make is that Abraham Lincoln learned an important lesson from the Exparte Milligan fiasco in 1861 that stuck with him for the duration of the war. When Taney issued his writ of habeas corpus for John Merryman, President Lincoln ignored it. This would not be the only time that Lincoln ignored the dictates of another department of the federal government. regarding the issue of habeas corpus. Lincoln's collision with Chief Justice Taney reinforced an idea for the president, an important belief that he had had about the Constitution since at least the Dred Scott decision of 1857. Namely, that each branch of the federal government could interpret the Constitution for itself in the exercise of its public functions. Now, as I previously mentioned, on March 3, 1863, Congress enacted the Habeas Corpus Act as an attempt to resolve the nation's civil liberties issues. The act had three important provisions. First, it authorized Lincoln to suspend the writ of habeas corpus. Second, as I've already described, the law offered some protection to Union officers who were being sued for wrongful arrest. And third, the act sought to protect political prisoners by stopping the use of military tribunals for civilians and instead requiring them to be tried in civil courts. Of the 14,000 civilians who were arrested by the military during the war, more than 4,200 were tried before military tribunals. In the Habeas Corpus Act of 1863, Congress sought to stop the use of military tribunals for civilians. The act required the Secretaries of State and War, William Seward and Edwin Stanton, to send lists to the federal courts containing the names of all of the civilians who were being detained by the military. If a federal grand jury didn't indict any of the people on those lists within the next term of the federal court, then the prisoners were to be released upon taking an oath of allegiance. Now, ironically, the Habeas Corpus Act deprived Lincoln of the ability to suspend the writ in any meaningful way. In his famous letter to Erastus Corning, Lincoln argued that the purpose of suspending the writ was to arrest civilians, quote, not so much as for what has been done, as for what probably would be done. As such, Lincoln claimed that he might arrest people who had not yet committed a defined crime, but who, if not hindered, these are Lincoln's words, were sure to help the enemy. Lincoln, in short, claimed the power to arrest and indefinitely detain American citizens who might be plotting against the government, but who had not yet committed a federal offense. And he believed he must be able to hold them until the time of public danger had passed. The terms of the Habeas Corpus Act, however, implied that the targets of military detention should be persons who were suspected of having committed an actual defined crime, that is, something for which they could be indicted in a federal court. The act thus placed the fate of disloyal civilians back into the hands of the federal judiciary, the very branch of the government Lincoln had hoped to bypass by suspending the writ of habeas corpus in the first place. Thus, while on the surface the Habeas Corpus Act appeared to give Lincoln what he needed by granting him the power to suspend the writ, in actuality it denied him the authority he had been claiming for the previous 2 years. Under the act, Lincoln could no longer hold civilians indefinitely. His administration was now required to supply lists of prisoners to the federal courts, and if those prisoners were not indicted, they were to be released. Furthermore, the requirement that detainees either be indicted or discharged demonstrates that Congress was not authorizing Lincoln to make the types of arrests that he believed he needed to make, that is, preventative arrests of persons who were suspected of disloyalty, but who had not yet committed a defined crime. The Habeas Corpus Act, in reality, only granted Lincoln a limited power to make emergency arrests, most of which would have to be of persons who could have been arrested anyway. The act, in short, made suspension of the writ of habeas corpus practically worthless. It is little wonder, then, that Lincoln disregarded it. In fact, Lincoln treated the Habeas Corpus Act in the same way that he responded to Chief Justice Taney in Exparte Milligan. He ignored it. Lincoln had a war to fight and a nation to save, and he would not allow himself or his administration to be hamstrung by another branch's interpretation of the suspension clause. In short, Lincoln never recognized the right of Congress to authorize the suspension of the writ of habeas corpus, and he continued to use the military to arrest, detain, and try civilians before military courts, the provisions of the Bill of Rights and the dictates of Congress notwithstanding. And as a quick aside, I'll point out that I actually have evidence that Chief Justice Taney had a hand in writing that provision of the Habeas Corpus Act, because he had a friend in Baltimore who was the congressman who wrote those provisions, and I found an account where the congressman passed them by Taney to make sure they were okay before introducing them on the floor of Congress. Again, there's more about that in the book. So, in the end, the Habeas Corpus Act proved an ineffective piece of legislation, offering little protection to union authorities and no protection to civilians who had been arrested by the military. Lincoln consciously ignored the act because he believed its terms inhibited his ability to prosecute the war effectively. Moreover, he believed that he, as president, possessed the authority to interpret the Constitution's suspension clause irrespective of what Congress or the courts had to say. As commander-in-chief, he also saw himself as constitutional interpreter-in-chief, and in those twin capacities, he did what he believed he had to do to win the war. Thank you.
Hi. I was wondering if you could discuss the suspension clause a little bit more. If I recall, Horace Binney wrote a pamphlet in support of Lincoln, arguing that at the convention, I believe the original suspension clause was in an Article 6.
Article 11.
Article 11, and it was the Committee on Style at the very end tucked it into Article 1, but with non-specific legislative language. So it's a great deal more ambiguous than just to say because you find it under Article 1, it's therefore Congress as opposed to the President.
Right. When Charles Pinckney of South Carolina first introduced a suspension clause at the Constitutional Convention on August 20th, 1787, and when he introduced it, the clause said habeas corpus will be suspended by the legislature in these circumstances. And that clause was sent to committee and never resurfaced. And about a week later, Pinckney reintroduced a suspension clause, and there was some debate at the convention. And when the convention voted on a suspension clause, it didn't include any language about who would suspend it. And then it was sent to the Committee on Style, and the Committee on Style, when it was sent to the Committee on Style, it was in Article 11 of the Constitution, which was, before the Constitution as we have it now, the portion of the Constitution that had to do with the judiciary. So it was in the judicial part of our Constitution. And the Committee on Style moved it to Article 1 of the Constitution. And there it is today. And there was no language that the convention ever voted on where it said would be suspended by the legislature or by Congress. And the record is ambiguous, and so I think Lincoln had a very plausible case to make where he said, I can suspend habeas corpus rights in this setting, because Lincoln said, the Constitution says you can suspend habeas corpus in times of rebellion or invasion. And he said, we have a time of invasion. And one other interesting point about the suspension clause, the language, the clause that the convention voted on said where in cases of rebellion or invasion the public safety may require it. And the one change that got into our Constitution was when. And in Lincoln's Corning letter and in other places where Lincoln defended what he was doing, he said, I can do this anywhere I need to because the Constitution doesn't confine me to where the rebellion or invasion is taking place. And Lincoln had a great argument there I don't know that he was familiar with the debates that took place at the convention on this specific point, but Lincoln had a plausible case that he could do it anywhere in the nation that he needed to.
Is there a direct connection between the events that you have just outlined, Exparte Merryman and Lincoln's ignoring of the Habeas Corpus Act, with Exparte Milligan in, 1867?
Yeah.
Is there, in other words, is Exparte Milligan Congress's attempt to reiterate in 1867 what Lincoln was ignoring in 1863?
Right. So one of the guys I mentioned at the very beginning was an Indiana lawyer named Lambden Milligan. And he was part of a secret society that historians debate how big the secret society was, but called the Sons of Liberty. And he was part of a conspiracy to free Confederate POWs in the Old Northwest, in Illinois, Indiana, Ohio, and try to form a Northwest conspiracy, and a confederacy, form a new nation. And in October of 1864, Milligan and 11 other guys were arrested by the military. This was right before the election of 1864, so it made for great campaign fodder. And they were tried before a military commission and sentenced to be executed. Well, after Lincoln was reelected, politicians, even the Republican governor of Indiana, wrote to Andrew Johnson, Lincoln and then Andrew Johnson after Lincoln was assassinated, saying, we shouldn't execute these guys. And at the same time that these appeals were going on for clemency, Milligan was appealing his case to the Supreme Court, and the Supreme Court heard the case in 1866. And the Supreme Court decided that that the president could not try civilians before military courts. Now, it's very interesting. David Davis, Lincoln's old friend from the Eighth Circuit in Illinois, wrote the opinion. And in the opinion, Davis intimated, during the war, I wasn't going to issue this kind of opinion. And in fact, the Supreme Court had punted earlier during the war saying, we don't have jurisdiction over this kind of case. But after the war, the court said, you can't do this in the United States. But what's interesting, and this is where it ties into your question, Salmon Chase, Lincoln's former Secretary of the Treasury, was now Chief Justice. And Chase wrote a concurring opinion in which 3 justices joined with him, saying if Congress authorizes military tribunals, then you can try civilians in court. And so the Supreme Court divided 5-4 on this issue of whether or not it was ever legal for civilians to be tried in military courts, with a 4-justice minority saying yes, if Congress had done that in the Habeas Corpus Act. But since Congress didn't do that in the Habeas Corpus Act of 1863, all 9 justices said that it shouldn't have happened. But they waited until after the Civil War to say it.
Thanks.
Sure.
I have 2 questions. How many men were in John Merriam's group, and who gave them support in the form of guns, horses, ammunition, and this sort of thing?
That's a great question. They were a militia unit of the state of Maryland, and so they had about 80 to 100 men, all from Baltimore County, and they got their arms from the state of Maryland. I found the Adjutant General records where they were requisitioning the state for material and getting guns from the state. There are accounts that say that they'd seized federal arms, but everything I can tell says that they got it from the state.
Thank you.
Sure.
Thank you. Excellent talk. I was curious if Lincoln ever tried to have Chief Justice Taney removed from office, and also if, in your research, Justice Taney, as being someone who was fairly pro-slavery, what were his thoughts on the creation of the Confederacy? Did he have any inclination, perhaps, to leave the court and to ally himself with that government?
Great questions. I'll start with the second one first. Taney favored the Southern Confederacy. His private correspondence shows that he wanted the nation to separate in peace, and he wanted the South to be able to go and have its own nation. And he wrote a letter to Franklin Pierce that the American Historical Association published about 100 years ago in the AHA's magazine or journal, in which he says the Confederacy should be allowed to go in peace. And so you can get that online. It's available to see. In terms of Lincoln and Taney, there was a rumor started after the war by Ward Hill Lamon that Lincoln was planning to arrest Taney. And Lamon is notoriously unreliable in certain respects. And so that's the only source I've ever found in which someone from the Lincoln administration or from Washington was saying that, yes, we're going to arrest Taney. It never happened. There were calls for his impeachment in northern newspapers, and I've seen some evidence that Taney believed he would be arrested. There was a bill introduced in Congress to abolish the Supreme Court in 1861 and to create a new Supreme Court, but that didn't go anywhere. There were also bills to abolish other courts in which Democrats were the judges, because federal judges have life appointment, and so the only way to get rid of them is either if they die or resign or are impeached, or you abolish the court. And the Republicans in Congress did actually abolish the federal court in the District of Columbia to get rid of 2 disloyal judges. And then they created a brand new court that was almost the same as the one they abolished, but Lincoln got to appoint 4 new Republican judges to the bench. But attempts to do that to Taney never went anywhere.
Was Chief Justice Taney ever friends with the Merriman family?
We'll have to ask the Merrymans that, who are here today. I don't, Carl Swisher, who wrote a very enormous, not quite as big as Michael Burlingame's biography. It's a minor volume about the Supreme Court, and Carl Swisher says that Merryman's father went to Dickinson College with Chief Justice Taney, but I've contacted the archivist at Dickinson, and he's found no record of Merryman's father ever being there. So that's the only instance I've found where there could be a connection, but I haven't been able to substantiate it. So I only footnote it in the book.
John, 2 quick questions. The first one, I want you to tell the audience after I ask my second question, about Simon Cameron's character and his Pennsylvania background. You're making him sound like a boring businessman, which he was anything but not, and what a malodorous character he was. The second question, I'm sure Herman Belz taught you about the great constitutional scholar John Codman Hurd. What did Hurd write in The Theory of Our National Existence in 1881 about Lincoln and the Merryman case? Do you remember?
I don't recall what Hurd had to say. In terms of Cameron, Cameron was known for being very unscrupulous. And, I mean, those of you who know the story about how when Lincoln was figuring out who would be in members of his cabinet, Lincoln promised a seat to Cameron and then found out about just how unscrupulous Cameron was, and then I think he sent a letter telling Cameron, sorry, you're no longer appointed, and then that didn't go over well, so then he appointed him Secretary of War. And Cameron wanted to be Secretary of the Treasury because that's how you make money, I suppose. But Cameron Cameron was notorious for buying elections. And in 1845, he bought an election to the Senate. In 1852, he did. He tried in 1863 to buy an election to the Senate in Pennsylvania. The Democrats had a one-vote majority, and Cameron was allegedly paying people $50,000, members of the state legislature, for their votes. And when the Democrats in Philadelphia got word of this, they went to Harrisburg and they lined the galleries with weapons, with orders to shoot any Democrat who didn't vote against Cameron. And Cameron lost that election. And then, he comes back later, but...
This is George Cadwallader, one of the Cadwallader Philadelphia aristocrats, too. He had a lot of money to lose in a damages suit,
he did.
too.
Cadwallader owned a lot of land in Maryland, and when he was being sued by Merryman, the sheriff of Harford County seized the land so that Cadwallader couldn't profit from it. So it was a very consequential suit for him.
My quick question was, did you look at the case of Exparte Field in Vermont in 1862? The judge held that habeas was suspended just because of martial law, and at the end, on the other hand, he said the marshal had to pay a $100 fine because at the time he made the arrest, the writ had not yet been suspended. Have you looked at that case?
I haven't looked at that case. Now, was that for a minor in the military, or was that for someone who was arrested for disloyalty?
Arrest for disloyalty.
Okay, I'll have to look at that. Thank you.
Oh.
John, apropos of the question about whether the President or the Congress had the power to suspend the privilege of the writ of habeas corpus, is it not the case that at the time that the suspension clause was revised to drop that phrase by the legislature, that the delegates in Philadelphia were considering the question of whether Congress would meet every year or every other year? And isn't it a reasonable inference then, since that was on their mind at the time, and since an invasion or a rebellion could take place when Congress was out of session for long stretches, that it would be reasonable to infer that the President was the agent who could really use that tool to suspend the privilege of the writ of habeas corpus in order to suppress a rebellion or to put down an invasion?
Right. Oh, absolutely. And that's the claim Lincoln made. Congress was out of session. And what could he do from April until July when he called them into session? He had to act quickly to do something to stop the rebellion from gaining steam. And Lincoln later said in 1863, if I had arrested Robert E. Lee at the beginning of this war, things would be going a lot better for us and we might be done by now. So he saw himself as having made more arrests.
Right.
Lincoln called Congress into special session on July 4th. That was a couple months after things got heavy. Should he have called Congress into session much earlier so he could get congressional support for his actions?
That's an interesting question, and I'm blanking on the reasons why he waited until July 4th. I know there were some elections that were taking place in June in various states. It's interesting. Even if he had called Congress into session earlier, they might not have ratified this decision. In the summer of 1861, Congress debated, do we pass a resolution saying what Lincoln has done in terms of civil liberties is okay? And a resolution was brought to the floor of the House, and it was never approved. The Congress did approve a resolution saying, we approve of what Lincoln has done in terms of raising troops and whatnot up to this point, but they never approved what he was doing in terms of habeas corpus until 1863. And even in the Habeas Corpus Act, Congress couldn't go far enough to say, they wouldn't say, we approve what he's already done. They used very vague language, the President is authorized And it was ambiguous. Was he authorized for what he did or only going forward? And it's because there were so many different factions of Congress, I mean, some things never change, that they couldn't agree, and so it took them 2 years. So I think even if he had called them in, it probably wouldn't have resolved that issue in April.
Perhaps an insignificant matter, but I'm wondering exactly how prominent Cadwallader was. If there was only one lieutenant general in the Army at the time of which we're speaking, and is it correct that he was a major general?
I believe he was a major general.
And I guess there were a slew of those, so was he one of the ranking ones, or what? I think the only difference is that was he a formidable person to be challenging in courts, is what I'm thinking.
He was a formidable person. He came from a prominent family in Philadelphia. His brother was a federal judge, and his brother had some interesting things to say about this case as well. His brother, the judge, thought the general got things completely wrong. Cadwallader was a Mexican War veteran, so he'd been a prominent person in the military for some time, but I don't know in terms of his rank among other generals. Well, thank you so much.